This program is brought to you by Emory University.
So again, welcome to the Child Welfare Legal Academy. We appreciate your interest in today's topic. With us today is Professor Paul Milich, who's going to discuss with you the evidence code and how it relates to juvenile proceedings and child prosecutions. And Professor Milich, if you're not familiar with him, is a renowned presenter on this topic. He's a professor of law at Georgia State University College of Law. We've also had the advantage of having him as a visiting professor here at Emory Law School, as well as did the University of North Carolina. And he has established himself as an expert because through 28 years, he's taught almost exclusively in the areas of evidence, advanced evidence, trial advocacy, contracts, and also legal history. I know Professor Milich's work mostly because of how well he is received and celebrated by our juvenile court bench. And I know he trains them regularly, particularly on these issues of evidence. And so again, our advantage here is to have the same expert giving the same information across to all of the practitioners in our juvenile court settings for the advantage of the clients being served. Professor Milich is also the director of the Litigation Skills Program at Georgia State. And prior to joining the faculty of Georgia State, he had graduated from Georgetown University Law School and practiced as a lawyer in Seattle, Washington. So probably some comparative advantage there across jurisdictions. Professor Milich has written numerous law review articles and has published a number of books, including Georgia Rules of Evidence and Courtroom Handbook on Georgia Evidence, both published by West. Professor Milich was the reporter for the Georgia State Bar Evidence Study Committee, which successfully drafted and promoted a new set of evidence rules for Georgia. Those rules will go into effect January 1st, 2013, and I'm sure that is why you are all here today. And we will deliver on that promise. Professor Milich has been honored by the State Bar in January 2012 with an award for excellence in legal scholarship. We can certainly join that award spirit if you'll help me in celebrating his presentation with us today and welcoming him to the stage so that we can turn it over to the reason you're all here, to understand the changes in our evidence code. Thank you, Professor Milich.
Thank you very much, Melissa, and thank you for all coming today. Excuse me if I have a little bit of a frog in my throat. I caught that horrible cold that's going around, the one that goes directly into your lungs, and it's gone now. I'm not contagious, but I still have a little bit of a frog in my throat, so excuse me for that. Yep, we're down to the last month of the old 1860 Georgia Code. It's almost time to say goodbye to it. It's been a long road getting it passed, but I guess you got to be careful what you wish for, because what I've done the last 6 months is basically been going around the state, teaching judges and lawyers and exhausting myself and trying to get everybody trained up, for this new rollout of the rules of evidence. We're the 44th state in the country to adopt new rules of evidence based on the federal rules. So we're not exactly going in uncharted territory, but it probably feels that way to a lot of judges and practitioners. A lot of the practitioners I've talked to, they say, well, I worry the judges just aren't going to learn the rules. And of course, I talk to the judges and they say, we worry that the practitioners aren't going to learn the rules. But as a matter of fact, what we've done over the last 6 months, I've done 5-6 hour programs that have reached, over 1,200 practicing attorneys, a lot of shorter programs. I've basically had the privilege of teaching every judge in the state at judge training programs. Some of these programs, juvenile court program, for example, with juvenile court judges was 8 hours over 2 days. So it's intensive soup to nuts training. And that's the idea here. It's not just passing new rules, it's also basically getting everybody retrained. And a lot of the judges and some of you practitioners probably haven't really looked at the rules of evidence since you went to law school. And this has been an opportunity for everybody to take a new look at that. Now, we have a couple of other sort of tools that might be useful in this transition to you. And by the way, Melissa, we have somebody handing out the clickers. Okay, good. I will need one. You all should get a little clicker. We're going to use Turning Point today and go through it's basically a multiple choice exam. And don't worry, we're not recording your specific answer. So you don't have to worry about me reporting to the bar or anything like that if you don't do that well. But we have a couple of other resources. One, which is out at the registration desk, is a 4-page cheat sheet, I call it. And basically what I did with this is I double copied it and laminated it, and it is what it is. It's my attempt to boil down the essential rules of evidence into 4 pages. So if you don't have a copy of this now, pick one up at the break. And I think all the judges basically are getting this. It's helpful in 2 ways. Sometimes you look it up and you'll actually get the answer to your question. But if you don't get the answer, at least you'll get a rule number, so you know where to go for the answer. A second resource is a law review article that I wrote for the Georgia State Law Review, basically called An Overview of the New Evidence Code. This looks at 38 significant changes between the old rules and the new rules. And it's broken down in terms of the changes which apply generally to all trials, and then special sections for changes in criminal trials and in civil proceedings. You can get this by simply going to the Georgia State University College of Law website, find the law review, and there, right there on their front page will be recent articles, including this one. You can download into a PDF format, and then you own it. Another resource is Courtroom Handbook on Georgia Evidence. Some of you probably have the older version of this. This is the green one is the new one. This has all the new rules. And what we did is in the preamble to the code, the legislature stated that its intent was to adopt, as near as possible, the federal rules of evidence as they are in effect and interpreted on January 1st, 2013. So what I did with the book is I seeded the book with tons and tons of citations and quotations from federal cases, primarily the 11th Circuit. So hopefully this gets us off, basically gets us off the ground and running right away. A copy of the Courtroom Handbook has been provided to every trial judge in the state by the Institute of Continuing Judicial Education. So every juvenile court judge, every state superior court judge, etc., all have a copy of this one. The bigger book, which I didn't bring today, is the treatise, Georgia Rules of Evidence. That's the full Monty. That's the entire volume of everything that I can think of to say about these new rules and Georgia rules. So both of those are available. So the cheat sheet, free. Law review article, free. Courtroom handbook, not so free. If you want to order the Courtroom Handbook or the Georgia Rules of Evidence, the number for West is on the cheat sheets. Okay. Yes. Oh, they don't need them now. No, they won't need them right now. So, okay, first thing we do is a little bit of technical work. We've got to program our clickers. And the trick to this is not to do it too fast. You go to either go or channel, whichever is in the lower left-hand corner button. You hit that, you hit 4, 1, and then go back to your go or channel button. You should get a brief green light that then goes out. If you get a flashing yellow or orange light or red light, do it again a little more slowly, a little more deliberately. Is everybody good? I'm sorry. No. Those of you, now, right now we're identifying the people who can't program their VCR. Channel 4, 1, channel, about that speed. Okay, are we ready? Got it? Everybody got what? There could be a couple defective ones out there. It might not be you. Does anybody need another clicker? Okay, then we're good to go. And the answers are just going to be simple to print. Just press 1, 2, 3, or 4, and that's it. And this isn't Chicago, so you can only vote once on any particular question. And once your question's recorded, it's in. You can't change it. There's no way to. And there's no I don't know. So on the first one in particular, I want everybody to answer so that I get a sense of what the base is. Here we go. In a custody hearing in Superior Court, the father presents hearsay evidence, but the mother never objects. Which is the best answer? Number one, error for the judge to rely on the hearsay, since hearsay is a legal evidence with no probative value. Two, not error if the judge finds that the hearsay would be admissible with proper foundation. Three, the wife has waived any hearsay objections, the judge may use the hearsay. Or four, wife's counsel should not sleep during the trial. So pick what you think is the best answer. Pardon? What would you think? Just guess. Would you spend your afternoon learning about the code that's going to be buried in 30 days? No. New code. New code. Just the number. That's all you need to do. Okay. Everybody has responded. We got 50 responses. We're going to use that as our base. And that's just, it's calculating, all right. That would be odd. Here we go. The 56% of you got the answer correct. The wife has waived any hearsay objections. The judge may use the hearsay. 20% of you, about 11 of you, are applying the old Georgia rule, which is hearsay is illegal evidence with no probative value. That rule's gone. We were the last jurisdiction in the United States to still have that old doctrine. Texas gave it up in 2005, leaving us alone. And it was a screwy rule. It was a trap for the unwary, and it drove judges nuts, juvenile court judges in particular, because they'd have to sit there and protect the record. Because, counsel sitting there sleeping or not knowing to make an objection, and the juvenile court judge is sitting there going, well, I've got to be careful here. If I rely upon hearsay, even if it wasn't objected to, I could still get reversed. That's no longer the case. It's use it or lose it. If a party does not properly object to hearsay, the objection shall be deemed waived, and the hearsay evidence shall be legal evidence and admissible. We added that to the federal rule to make it completely clear that we were killing this old 19th century doctrine. And this is the basic application of the rules of evidence shall apply generally to all non-jury trials and other fact-finding proceedings of any court in the state, subject to certain limitations. And that includes an exception for juvenile court proceedings, which are dispositional hearings and custody hearings in juvenile court. So we have a little bit of a difference here. In Superior Court, rules of evidence still apply to a custody hearing under 2412B. And it applies to all non-jury trial and other fact-finding proceedings of any court in the state. The juvenile code, of course, it basically says that any evidence is admissible at a disposition hearing. And the Court of Appeals, of course, has written conflicting cases on that point and said, well, wait a minute. When you say any evidence, it can't be illegal evidence, so it can't be hearsay. So we've had problems with that. All those problems are settled with the new code. Okay, there's no longer any alleged conflict between the notion that hearsay is illegal evidence and the liberal rule with regard to the admission of hearsay in a dispositional hearing. So that no longer exists. Therefore, a dispositional hearing in juvenile court, basically rules of evidence shall not apply to a dispositional hearing and custody hearings, except, of course, the rules with regard to privileges. That still does apply. Number two, in an administrative hearing, petitioner offers the testimony of an expert in something or other, doesn't matter. The respondent brings a Daubert motion to exclude the expert's testimony. Number one, the ALJ should set a special hearing to consider the Daubert motion. Two, the ALJ should have the parties brief the motion but hold no hearing. Three, no hearing is required. Daubert is not strictly applied in administrative hearings. Or four, who is Daubert and why is he bringing a motion? And, well, that's kind of small there. The correct answer is three. which I think 38% of you got. When we were in the legislature, we responded to the concerns of workers' comp judges and administrative law, other ALJs, who basically said, you know, we have bench hearings, we don't have juries, and we're getting basically clogged with these Daubert motions. And so what we did was we added a new subsection G to the Daubert statute, which, as you can see there, says that Daubert shall not be strictly applied in proceedings conducted, and that's, of course, a reference to a workers' comp statute and in other administrative proceedings controlled by the Administrative Procedure Act. So we relieved the ALJs in these circumstances from having to deal with Daubert motions. It didn't really make a lot of sense. When you think about it, the whole point of Daubert is a gatekeeping function. And the gatekeeping is to stand between the evidence and the jury and make a reasoned and thoughtful decision as to whether the evidence is sufficiently reliable and based on good science or other technical bases to get to a jury. Well, if you're both the fact finder and the evidence decider, then who are you gatekeeping for? You're gatekeeping for yourself, which, you know, I shouldn't consider this. You know, I mean, it's silly. And so I've been teaching ALJs for years, ever since Daubert was decided. Don't ever grant a Daubert motion, because you can be reversed on that. That's a legal decision you can be reversed on. So what you should do is say, I'm going to let it in for what it's worth, and then disregard it in your finding of facts, where you're bulletproof. And the judges are like, yeah, duh. So they've been kind of basically just sort of going through the motions with it anyway, and we decided to go ahead and add this provision to make that a little clearer. Okay, in a divorce case, wife offers a letter husband wrote to his counsel. Husband asserts the attorney-client privilege. Wife claims no attorney-client relationship existed at the time the letter was sent. Now, this creates a preliminary question of fact. When was the attorney-client relationship formed? In deciding this factual issue of when the relationship was formed, number one, the judge should let the jury decide the issue. The judge decides the issue based on evidence admitted at trial using a preponderance standard. Or three, the judge decides the issue based on any non-privileged evidence, including hearsay, using a preponderance standard. Or four, the judge should flip a coin. Excuse me. And number three is correct. That's 104A. Currently, under Georgia law, we have no directions to the trial judge as to how to handle preliminary questions. There's no statute. The case law is confusing. And so most judges have their own sort of idiosyncratic way of dealing with it. Under the federal rules, we have kind of a neat system. There are two kinds of evidentiary issues that trial judges face. Most of them are technical evidence issues. Is it hearsay? Is it come under an exception? Is it character evidence? Is it privilege? These are all technical legal issues. Another way to describe that is these aren't issues the jury gets. Okay, jury doesn't understand what the hearsay rule is, or what the business record exception is, or what the psychotherapist patient privilege is. That's lawyer stuff. And for those kinds of lawyer type legal objections, we use 104A. And 104A tells the trial judge, look, you got to decide any factual matters in order to decide the legal issue. You can consider any evidence that's not privileged, most importantly, including hearsay, in deciding that issue. And this really unshackles the judge compared to current Georgia law in getting to the bottom of these legal issues and resolving them quickly. And another implication of that is gone are the days in which we instruct the jury to make evidentiary decisions. Under current Georgia law, you got a co-conspirator rule. You tell the jury about it and instruct them on how to apply the co-conspirator rule. Or if it's an agent admission, you give an instruction telling them how to apply that and to ignore the evidence if they don't think it fits under the exception. No more. That was a crazy idea, always stupid, asking jurors, oh, no, let's explain conspiracy to you, jurors. Right, that's not worked, it's not been successful, and Georgia's going to get out of that business as of January 1. So that's good. All this now funnels through the trial judge, and the trial judge is responsible for making these decisions. Now, we're going to see some examples here as we go through some of these questions of 104A in action and how it really cuts through a lot of the game playing that too often eats up time and judicial resources, and of course is very frustrating to litigants and to judges. The philosophy of the Federal Rules of Evidence is to streamline the things that really aren't contested and to get to the merits of the case. And we'll see that in some of these provisions. In a hearing on a petition for a protective order, petitioner offers a letter allegedly written by the respondent. The respondent objects that the letter is a forgery. In deciding whether to admit the letter, the court should admit the letter if there's sufficient admissible evidence that a reasonable fact finder could find the letter is authentic. 2, the judge should admit the letter only if the judge is convinced by a preponderance it is authentic based on evidence admitted at trial. 3, the judge decides the issue based on any non-privileged evidence, including hearsay, using a preponderance standard. Or 4, the judge should ask her law clerk. This is the best answer, not what's most often happens. And the correct answer is 1. So a quarter of you are going, yes. The other 75% are going, what? All right, this is the other kind of evidence objection we get at trials. Okay, 2 kinds. Remember, the first kind is a 104A. That's your technical legal issues. Is it hearsay? Is it character evidence? Is this expert qualified, et cetera, et cetera. The second kind are relevance-based objections, which in the federal system we call 104B issues. Relevance-based objections are ones which go to whether or not the evidence is even relevant in the case. And the biggest example of this is authentication. All authentication questions are 104B questions. If you can't prove that this letter was actually written by the respondent, we don't know who wrote it, then it has no relevance in the case. It's just some random letter. If the prosecution can't prove that this pile of cocaine is the same substance that was seized from the defendant at the time of his arrest, then it's irrelevant. It's just some random pile of cocaine. That connection of showing that the thing is what a party claims it to be is essential to the relevance of the evidence. Notice the other thing here, 104B issues are issues that juries do get. They may not understand hearsay, but they understand the difference between an authentic letter and a forgery and the issue that portrays. They understand the issue of, is this the same cocaine that was seized from the defendant? They get that. And the earmark of 104B issues, of course, is they are issues ultimately for a jury, for the fact finder. So how does that play out in terms of the rule? Well, the judge in a jury trial only performs a gatekeeping function with regard to 104B evidence. The judge, for example, going back to our cocaine case, says to the prosecutor, what evidence do you have of chain of custody here? And the job under 104B of the judge is to basically say, you better show me that you have sufficient evidence that a reasonable jury could find that this is the same substance that was seized from the defendant. Now, I might, if I was a juror, I might think, no, you haven't proved it enough. But reasonable people can differ, then it goes to the jury. So notice with authentication, it's the lowest standard of proof we have in the law. Could a reasonable fact finder find this is what the party claims it to be? So 104B, the judge looks at any evidence that the jury's going to see and then decides based upon that evidence, could a reasonable jury find that it is what the party claims it to be? Now, how does that work out in a situation like this, a motion for protective order, where the judge is also the fact finder? Well, frankly, the judge is smart to basically say, I'm going to admit it for what it's worth. And I'll make my final consideration as to what weight, if any, to give it when I decide as a fact finder my final findings of fact. So don't be surprised if in these contexts, if you're making an authentication, well, we think this is a forgery, that if the judge is deciding that is, the judge is the fact finder, the judge is just basically going to say, everybody put on your evidence. You try to convince me that it's a forgery, you try to convince me it's authentic, I'm going to let it in. But I'll decide at the end of the case what credit, if any, I'm going to give it. That's just smart for the judge to do. Again, whenever a judge can defer their decisions, take them out of making a legal evidentiary decision, and defer that decision to a fact-finding decision in a bench trial context, the judge is much more protected for reversal. And every judge understands that. So don't be surprised if you're saying, well, this is ridiculous. I mean, they have no evidence really connecting this. Now, we're going to see a couple of examples in a few minutes of bright lines where the judges have to be careful, and we'll get to those. But before we do that, let's sum up what the difference between 104A and 104B is. And by the way, I'm going to give Melissa a copy of all these slides after the program. And so she'll make those available, either posting them on the site or whatnot, so you'll have the whole thing with all the answers and the explanations. Okay, so you see by this chart, if it's a 104A question, the judge decides it. The judge can consider any non-privileged evidence, including hearsay, and the standard of proof is preponderance of the evidence. On the other hand, it's a 104B question. The fact finder, the jury, is the ultimate decider. The judge looks at any evidence that will be admitted and decides, could a reasonable jury fact finder find that it is what the party claims it to be. One simple way, simple test for distinguishing between a 104A and a 104B question is this. If the objection before the court is valid, would that destroy the relevance of the evidence? The answer to that is yes, it's a 104B question. The answer is no, it's a 104A question. So I'm offering a business record in evidence. The other side objects. Objection. This does not meet the requirements of the business record exception to hearsay. If that objection is valid, does it destroy the relevance of this business record? No. It just disqualifies it for a technical exception to the hearsay rule. Okay, it's still relevant. It is what it is. So that's a 104A question, as are almost all hearsay questions. On the other hand, if I'm offering a letter in evidence and somebody says that's a forgery, you can't prove that my guy wrote that. Well, if that objection's valid, it completely destroys, obliterates the relevance of the evidence. It's no longer tied to the party, and who knows where it came from. Therefore, that's a 104B question. And you'll see as you pass into these new rules of evidence, it'll become quite common, as it is in federal courts, for people to say, oh, Your Honor, it's a 104A issue, and this is what we're presenting on that issue, or this is a 104B issue. Number 5, in a divorce case, wife offers a copy of a medical record that states that the wife was diagnosed and treated for 3 broken ribs. The doctor is not at the trial. The record is accompanied by an affidavit that includes all the assertions contained in new OCGA 249-90211. The record and affidavit were provided to the state 4 days before the trial with written notice of intent to offer the same into evidence. Well, this shouldn't be the state, obviously. This should be the husband objects that the note is hearsay. Which is the best answer? Sustained, you need a live witness to lay foundation for a business record. 2, sustained, opinions are inadmissible in a business record. 3, sustained, no foundation that the author of the record was qualified as a medical expert. Or 4, overruled. If you're not sure, just go ahead and guess. That's what judges do. Very good. 59% of you got that one right. Overruled. This is going to work. This is going to be a tool that everyone's going to, within about a year, it's going to be used quite broadly, particularly in criminal cases. But there's also a lot of places that you can use it on the civil side as well. 90211. 90211 allows you to get a certificate from a records custodian that not only authenticates the document, we're used to that, but also meets the qualifications for the business record exception. Isn't that neat? Now, of course, in most civil cases, like personal injury cases and stuff, we've had other tools to do this. You know, I used to always use requests for admissions. Now, more and more, the pretrial order process in the civil side is pre-admitting these types of records without the need to call witnesses to lay these boring foundations for the business record exception. But in criminal sphere, that's not the case. In the criminal sphere, we don't have those tools. And so the feds back in 2000 said, you know, it's so much easier and efficient to admit these business records in civil cases and criminal cases. And yet, you know, civil cases can afford calling these witnesses more than criminal cases are. That's an unnecessary expense in the vast majority of circumstances. So how does it work under the new rule? Well, suppose, and this is based on a real example that was in federal court, and I'm going to talk about how the judge handled it there, like how we're going to be handling it after January 1. In this particular case, the U.S. attorney needed some records from an internet provider out in Oregon. Now, under current Georgia law, you would be forced to basically fly that guy out here, put him up in a Holiday Inn Express, feed him a little Georgia barbecue, or walk him into trial for his 15 seconds of fame, and then take him back to the airport and fly him back to Oregon. What a waste. What a waste of money. Because you know the defense counsel is not going to stipulate to that. That's not what they're hired to do. And what can you do under this new rule? Well, you take the records, you put the certificate on top. What's the content of the certificate? Just what the rule says. It's a neat rule. I call it a cut and paste rule. You can cut and paste the language from the rule right in the certificate. That's all that's required. And then you have the signature line. He has to sign it under penalty of perjury. So he can either sign it in front of a notary or just assert he signed it under penalty of perjury. That's it. Put that in a FedEx envelope, ship it off to the record custodian in Oregon. Record custodian signs it, ships it back. You got to give pretrial notice, a heads up to the other side. How much? This rule doesn't say exactly. And the reason the rule doesn't say exactly is basically when you set those kinds of time deadlines, they end up causing food fights because somebody misses the deadline by 24 hours, and it really has any practical importance at all, but of course they're going to fight over it. And what they do in federal court, they basically say, you want to get this to the other side in a timely enough manner that if they have an issue about it, we'll have time to resolve it. And if you don't give it to them soon enough, then, and the other side is basically can't get it resolved by the time of trial, then it's too late. So what if there is an objection? I asked this federal magistrate who's been on a bench for 10 years, and this statute 902.11 has been around for about 11 years. I said, how many actual objections have you had to these certificates? 2. I said, well, how do you handle them? He told me the story about the Oregon records. He says, defense counsel calls my clerk and says, I have an objection to these records. I don't think they were made in the ordinary course of business. I think they were made in anticipation of litigation. Here's how the judge handles it under 104A. The judge says, okay, tomorrow I want you and the prosecutor to call in on a conference call. We're going to call the record custodian out in Oregon and patch him into our conference call. We're all going to sit probably in our pajamas, and we're going to ask questions. And when we're finished asking those questions, then I'm going to make a decision based on the preponderance of the evidence about whether this record meets the rule. That's it. That's it. It took 5 minutes. The defense counsel had a couple of questions. The U.S. attorney had none. The judge thanked the custodian of records and hung up and said, I'm satisfied this meets the requirements of 8036. Boom, it's in. Done. Okay, so instead of making big hullabaloo and emotions and all this stuff on a very, very simple question, because it is, isn't it? It's a very simple question. And you're thinking, what, but that phone call, isn't that all hearsay and it's not sworn and it doesn't matter. Any non-privileged evidence, including hearsay, can be used to attack a 104A issue. So you notice here that the emphasis is on dispatching these kind of problems, not allowing one party to make a mountain out of a molehill. And which, as all you litigators know, sometimes is done for not the best of reasons. It's certainly not to get to the merits of the case. It's because you hope you can maybe, distract the other side, or you can maybe cost them some more money, or you can do these kinds of things. We're trying to weed those kinds of gamesmanship out of the system. Now, as I've gone around the state and talked to civil defense attorneys and criminal defense attorneys in particular, there's a little bit of whining about that. You know, they're like, oh, wait a minute, that's just fun to do that. I like gamesmanship. I like, you know, and I say, I know. And old habits will die hard, but the federal rules aren't going to support that type of habit anymore. As to notice, it only requires enough to give the opponent a fair opportunity to challenge it. Okay, and now since we can do these things by phone conferencing and stuff, that might be a very small window of time. But if somebody comes marching in the morning of trial with a certificate and say, oh, here's my notice, and they bring that up with the judge may say, oh, okay, we'll make one shot at this, we'll try to call the record custodian, but if he's out to lunch, you're dead, you know, because you didn't give enough time, okay? And likewise, the opponent can't wait till the last second to make an objection. They have to basically allow enough time, a reasonable time, to give the judge a chance to get to the bottom of it. Now, a big change here, the new business record exception expressly allows opinions in the record. Our Georgia business record exception didn't, which really reduced its utility. We were one of the only states in the country that had such a limited business record exception. So now we'll be able to get, for example, like here, medical records into evidence without calling the doctor, Now, well, how do we know that that's a doctor then? He doesn't show up in his little doctor smock. How do we know he's really a doctor? Well, first of all, authentication of medical records from a doctor's office is prima facie evidence that it's a real doctor's office, okay, just by the authentication. That is the certification itself. And secondly, going back to 104A, one judge said, well, what if defense counsel's jumping up and down? He says, I've never heard of this doctor. How do I know he's licensed, you know, to practice medicine in the state of Georgia, I said, you know, under 104A, do you know what you can do? You can call counsel all back in the chambers, sit down to the website for the Medical Composite Board of the state of Georgia, look up the doctor, boom, there he is. He's licensed, active license to practice medicine in the state of Georgia. Now, what's your problem, defense counsel? You know, I mean, again, 104A allows us to basically get to the bottom of these. I mean, that's what business people do. That's what ordinary people do. When you have a question, you know, you get to the bottom of it, and then you decide what's most likely to truth. We're going to do more that way rather than formalistic ways under the new rules. So the medical narrative statute, some of you are aware of that can be used in deprivation proceedings, used in personal injury proceedings and whatnot. We still have that. It's been renumbered, okay? But you can see now how we might have a situation where the underlying medical records would be admissible under the business record exception, and those are not admissible, right, under the narrative statute. And then we'd have a narrative over that, a summary over that would come in. That wouldn't be admissible under the business record exception because it's made in anticipation of litigation. So you use two rules, business record exception for the underlying medical records and a narrative exception for the doctor's summary of the case. And you could put those two together into a nice little package. And again, you don't have to have the doctor testify in order to get that into evidence. Number 6, in a support hearing, mother offers a properly notarized document in which husband states that he received certain funds on a certain date. Defendant objects that the document is not authenticated. Number 1, sustain. The subscribing witness rule requires the testimony of the notary who witnessed the defendant signing the document. 2, sustain. Plaintiff must offer testimony from someone who recognizes the defendant's signature on the document. 3, overruled. The notarized document is self-authenticating, and this is an admission. Or 4, overruled. Mothers never lie. And you killed that one. Number 3 is correct. Believe it or not, under the current Georgia law, if you get something notarized, you bump into the subscribing witness rule, which makes it harder to authenticate than if it isn't notarized. It's crazy. Because you notarized it, you have a subscribing witness who you now must produce in order to authenticate it or explain that they're dead or out of the country or cannot be, you know, it's crazy. So you'd be smart in Georgia, under the old rules, not to notarize documents if you want them to be authenticated easily. And of course, that's just the opposite of our instincts. And the federal rules follow our instincts here. Documents which are notarized are self-authenticating. And that means you don't need a witness at all in order to authenticate them. The subscribing witness rule is basically abolished unless there's a specific state law which requires in a specific instance, a witness be produced. That applies in some states. Wills are not valid without a subscribing witness's testimony. Georgia, of course, has a self-authenticating will provision. Most states do now. In a criminal assault case, a police officer testifies that he called the phone number listed for the defendant Brutus. The person answering the phone identified himself as Brutus. When the officer said he was calling about a bar fight the previous night, the person said, well, he made fun of the rule against perpetuities. I had to hit him. The defense objects on authentication grounds. Well, one, overruled, the person admitted he was the defendant Brutus. Two, overruled, the call was made to the defendant's number, he identified himself, and they talked about the incident. Three, sustained unless the officer recognized the defendant's voice, or four, sustained unless the call was recorded. And two is correct. 73% of you got that right. And I'm glad to see that there was very little attraction to number one. The person admitted he was the defendant Brutus. Now here is one of these bright lines we were talking about with authentication. All the case law in current Georgia law and in the federal system. Self-identification by itself is never enough to authenticate. Either a phone call or an email, a letter, whatever. You got to have something else. It's self-identification plus, that's what you need. If all you have is the skinny fact that the person identified himself as so-and-so, and you don't have any other clues to corroborate that, then you're out of luck. You're out of luck. And judges understand this. They understand that there's that pretty bright line, that's just simply legally insufficient as a matter of law. So you need to come up with something else. Now here, we've got a couple of things, and the rule, of course, helps us. The rule is 9016. It says, well, you know, what else do we have? Well, we have the person who's testifying says, like, I called the number that was assigned to Brutus. Well, one would expect that the person would respond Brutus. Okay, so you call the number assigned to him. Number two, the content of the conversation included things that only Brutus and a few other people would know. We talked, in other words, about he was at the bar previous night. He talked not knowingly about the fight. That's something that just any random person, if I misdialed, would know what the heck I was talking about. So all those things are additional clues which authenticate the phone call in this circumstance. In the case of a business, if the call was made to a place of business, and again, the content of the conversation related to business reasonably transacted over the phone, that's going to admit it. So what you're going to see here under the new rules, the federal rules, authentication of things like phone calls and emails, et cetera, is going to be easier. Is going to be easier. Georgia has some of these old cases, not always consistent, which sometimes, obscure, what the job is here. And the job here is not for the judge to decide qua judge whether he or she believes that this, in fact, was Brutus on the phone. That's ultimately a question for the finder of fact. That's ultimately a 104B question. Okay, the judge should only exclude it if there's legally insufficient evidence. That is, no jury, no fact finder could reasonably find that this was sufficiently authenticated. Likewise, here in a divorce jury trial, husband offers an email he received from Pierre Legrand. He says, I love your wife, and I want to take her with me to Disney World. Is this okay? Wife objects the email is not authenticated. Overruled, the fact that the email said it was from Pierre is enough by itself to meet authentication requirements. Two, sustained without more evidence tying the email to Pierre. Three, sustained if the court decides it has not been proved by a preponderance of the evidence that the email is authentic. Or four, sustained, Pierre is clearly nuts. And 2/3 of you got that right. There's just not enough here to tie this thing to Pierre. It says it's from Pierre, but even under current Georgia law, as well as the new code, that's not enough. Okay, the mere fact that it says it's from Pierre is not enough. Then the content is almost silly. I love your wife, I want to take her to Disney World. There's no content there that corroborates it in any real way. So this wouldn't be enough. You would have to have more. Well, what could you have? Well, for example, if it's an email, if you had the headers, okay, everybody know what headers are on emails? Okay, you don't normally see them, you have to press a special button to see them, but it will basically show, among other things, the IP address of the sender. And if you can basically get a copy of that and tie that to the IP address of Pierre and his computer in his house, now you've got self-identification plus some decent evidence that corroborates it. But just the name, just the email account name is not going to be enough. Number 9, in a divorce case, a wife offers a printed copy of a Facebook page that appears to be her husband's. The page includes family photos and messages posted by family friends. It also includes some salacious messages by the husband to someone other than his wife. The husband objects that the page is not authentic. Overruled if the wife testifies that she recognizes the family photos and friends who posted on the page. 2, overruled if the page was password protected. 3, sustained unless the wife can prove the page was created on husband's computer. Or 4, sustained the wife shouldn't be snooping on husband's Facebook page. And 52% of you got that right. Now, it wouldn't have to be proven that it was made on husband's computer. And in fact, you can make a Facebook page on any computer. So it's not something that is tied to any particular hardware. And that's the point here. So whether it's password protected or not, you know, the problem with connecting things to hardware is a lot of people use different hardware. We have a password protection system at Georgia State College of Law. We have to change it. You know, every week we have to change it. And it has to be, 9 characters long. 4 of them have to be Chinese. And yeah, so I do what probably most of my colleagues do. I write the password down on a Post-it note and slap it on the side of my computer. So to say something's password protected isn't exactly, Fort Knox. So, it's oftentimes the easier route to authentication, particularly something that's so rich in detail, like a Facebook page. I mean, that's why they creep me out, and I don't have one, is they're so intimate. I mean, I look at our vacation photos. Here's my wife in her bikini. What are you doing? Showing this kind of stuff to people. But whatever, it makes it very easy, as a matter of fact, for someone who is familiar with the alleged owner of that page to basically say, I recognize all this stuff. I recognize Aunt Belle here. And yeah, I recognize the pictures of our vacation up in the Poconos last year. And yeah, I recognize Fred, that's his best friend, they're at the Falcons game. All of this information that obviously has been compiled with somebody with all this intimate knowledge of the alleged owner is enough that a reasonable jury could find that it is what it appears to be. And judges are trying to understand this more and more as we move deeper and deeper into electronic evidence, text messaging, tweets, all this other stuff. They understand how penetrable these systems are and how easily spoofed and forged they are. And they are. That's a reality. But they also understand that the fact that these things are easily forged and spoofed can't stop the courts from ever admitting them. Because, my students hardly ever write. And I asked my students in my evidence class a few months ago, how many of you have written a personal letter with ink that you put in an actual envelope and you put on a stamp on it and you send it to somebody? There were no hands in the entire room of 80 people. No, it's like, why would I do that? And I get that. I don't send a whole lot of personal letters anymore either. But so we're all communicating in this way, and the courts are aware of that. So their attitude is we let the frailties and the vulnerabilities of the system go to weight and not admissibility. If in a particular case you think that this is a forged Facebook page, a forged text message, etc., then you're going to put on evidence to try to convince the jury of that. And you're going to use the known vulnerabilities of these systems. and how easily penetrated and fake they are in order to try to bolster that. But we all know that the vast majority of these communications are quite uncontroversial. They are what they seem to be. And so what the basic default rule is, let them in with a modicum of some foundation. The more clues, the more corroboration you can create, the better. But ultimately, these things are going to be jury questions. Here's the particular rule you would use, for example, for the Facebook page. You would point to the appearance, content, substance, internal patterns, or other distinctive characteristics taken in conjunction with circumstances. Here's another one. A divorce case, husband offers a computer-generated printout from a GPS tracking device that indicates the wife's car went to her alleged paramour's home 10 times in 1 week. Wife objects on hearsay and authentication grounds. Number one, overruled with proper foundation under the business record exception. 2, overruled if foundation evidence describes the system used to produce the report and supports its accuracy. 3, sustained unless an expert verifies the report. 4, sustained, this is too creepy, and yet it's becoming quite common. I was looking at a web page the other day in which it basically said, find out where your spouse is going. And it was advertising the GPS, the cheap GPS system. And then they had a link, look at our other products. And one of their other products was how to listen in on your wife's cell phone conversations. This is getting too creepy. But, it's a new world. Very good. 2 of you nailed that. That's the correct answer. As we move forward with our electronic society, more and more things are being recorded without the intervention of a human being. I'm old enough to remember when I worked at a gas station in Venice, California, with the old credit card things, where I would go up to the pump after it was full, I would write down the gallons, I'd write down the total amount, I'd fill in information, and the credit card, give the receipt to the customer and whatnot. Now that is a record made by a human being. Okay, I could make a mistake in writing down this information. I could fabricate or lie when I wrote down that information. So that's hearsay. Because of the danger that I could be lying or mistaken, it is hearsay. Well, how do you do it now when you go to the gas station? You just swipe your card. There's no humans involved at all. There's no hearsay. Likewise, when you go and you buy a 6-pack of PBR at the grocery store, they just scan it. There's no human intervention. So you need to start looking at these kinds of evidence and say, is it machine generated? If it's machine generated, you don't have a hearsay problem. All you have is an authentication issue. That's all you have. And that's all you have with this GPS system. You just need somebody to testify as to their understanding of how it works. And that doesn't mean technical understanding. That doesn't mean they need to understand the satellites in the sky. Okay, how would you lay foundation for a GPS under B9? Simply, the husband could testify, yeah, I bought this system. Wanted to see how it worked, so I put it in my back seat and I drove around. I drove to the Publix, I drove to my kid's soccer game, I drove to my mistress's house, and then I went home. And then you get online and they give you a code to type in. I type that in, and boosh, there it is. The company's computer has recorded my GPS signals, correlated them on a map, and there I've confirmed, yeah, it went. I did go all those places. It's accurate. Then I put it in my wife's car, and away we go. Okay, that's all you need. You don't need an expert. You just need somebody who's used the system and can testify affirmatively to its reliability. They don't need to know how the system works. So, if you want to prove in a DUI case that the driver had bought a fifth of vodka 15 minutes before he ran into a telephone pole, you can bring in the clerk. Now, he doesn't remember anything about this guy, but he basically says, you show him this receipt. What is it? What was one of our receipts? How are these created? Well, I take the vodka, I run it over this little glassy thing with some red lights coming out of it, and then the machine, goes zoom. And I look at it and go, yeah, it says vodka, and it says the right price. And then I put it in, I take the money, and off he goes. That's it. Okay? He doesn't have to understand how scanners work. all right? That's not important. He just has to understand that, he just has to have knowledge that it is, in his experience, it produces an accurate result, and that's all. Again, so notice how we're trying to cut through a lot of the formalism here and get down to more common sense resolutions of these types of problems. So with our GPS tracking system, there is really no human intervention of any significance. Now, as the layman's case says, to be sure, there can be no statements which are wholly machine-generated in the strictest sense, since all machines were designed and built by humans. But certain statements involve so little intervention by humans in their generation as to leave no doubt they are wholly machine-generated for all practical purposes. So, for example, when you get pulled over for a DUI and you blow into the intoxilizer and a number comes up, that's not hearsay. That's not hearsay. No human being is in that little box, trying to, measure or calculate. It's being done by the computer chip. All right. Same way with caller ID. Caller ID pops up. All right. That's presumptively just simply machine generated. So these kind of things are not treated as hearsay. Number 11, in a prosecution for driving with a suspended license, the state offers a certified copy of a record from the Department of Driver Services, which states that notice of suspension of defendant's driver's license was sent to defendant. The defense objects on hearsay and confrontation grounds. Number 1, sustained, the record is testimonial hearsay. 2, sustained unless there is foundation qualifying the record under the business record exception to hearsay. Both 1 and 2. Or 4, overruled non-testimonial hearsay that qualifies under the public records exception. Very good. 71% of you nailed that one. Okay. Current Georgia law basically says this with regard to public records. Either you find a specific statute that addresses that particular record and admits it, or you go over to the business record exception and try to shove it through there. Completely changing that under the new rules. Under the new rules, public records have to come in under the public record exception 803.8. Private records have to come in under the business record exception 803.6, and the two shall not meet. So if you can't get a public record in under the public record exception, you can't run over to the business record exception and try to get it in there. Okay? And that's because the public record exception is designed specifically for some of the issues with regard to public records, particularly their use in criminal cases, as we're going to see. Now, there are three subsets for public records, 803.8A, B, and C. And here we look at the easiest one, 803.8A. These are the mundane records of a public office, the kind of stuff that they keep all the time in the ordinary course. Driver's records, corporation records, professional licensing records, tax records. You get the idea. Just that huge mountain of different kinds of public records that institutions hold, not for the purposes of litigation, but for basic record keeping as part of their either regulatory function or whatnot. So in these contexts, this is the easiest stuff to get in. All you do is you certify the record, which makes it self-authenticating, and then you just tender it into evidence under 803.8A. So you need no witness for such a record. And it makes it quite simple. And of course, by definition, 803.8 records are going to be non-testimonial when offered by the prosecution in a criminal case. Because by definition, they were not made in anticipation of prosecution or for the purpose of prosecuting or investigating criminal activity. They just were there and then happened to become relevant in a subsequent proceeding. This is a case on point with regard to these are not testimonial because they're akin to business or public records, did not contain assertions or accusations made after the fact or in preparation for litigation. Now, the old statute, 24-720, which allowed for the very simple certification of Georgia records without a seal, was kept, just renumbered. Now, with regard to the numbering system under the new rules, we tried to make it simple that if you knew the federal rule, you could generate the corresponding Georgia rule. So how do we do that? Well, let's take 8036, business record exception, federal rule for the business record exception. Well, the first two digits of the Georgia code, of course, are Title 24. So it's 24 dash the first number of the federal rule, 8, and then the federal rule, 8036. So if you know that the federal rule for business record is 8036, then you know the Georgia version of that will be 24-8-8036. So it's always easy, if you know the federal rule, to generate the Georgia one. Now, we kept over some old Georgia statutes, but we needed to renumber them to put them in the right chapters. So what happens is when we run out of federal rules on authentication, I think that's 913 is the last one, then we jump up to the next decade, in this case 920, and we start numbering the old Georgia rules. So if you know there's an old Georgia rule on authentication, you want to see if it still exists, then just go to the back end of 24-900s, and it should be there. Okay. Also, by the way, in the courtroom handbook, there's a table which shows old Georgia statutes which have been retained, what their new number is and how to find them. And if there's an old Georgia statute that's not on that list, that means it's gone. That means it was abolished. But if it still exists, we renumbered it like this. And again, Georgia records will continue to be authenticated with simply a written certification, no seal required. We also kept the statute many of you are probably aware of with regard to information taken from a terminal lawfully connected to the GCIC. Okay, number 12, plaintiff has sued Freddie Cakes for injury suffered when a driver of a truck with Freddie Cakes painted on the side ran a red light and struck the plaintiff's car. Plaintiff would testify that while at the ER, a few hours after the accident, Bob, the driver of the bakery truck, told her, "I'm so sorry, this was all my fault. I was lighting a joint and I didn't see the red light." Defense objects, this is hearsay. Sustained, the driver was not authorized to speak for his employer. 2, sustained, you can't use the sign on the truck to prove the driver worked for Freddie Cakes. 3, overruled, the sign on the truck proves the driver was an employee and his statement concerns something he would know by virtue of his job duties. Or 4, overruled, falls under the pothead exception to hearsay. Nobody picked 4, very good. The correct answer is number 3, and this is a big change. Current Georgia law is number 1, isn't it? That's why some of you picked that. The driver was not authorized to speak for his employer. We'll talk about the sign in a moment, but here's the new agent admission rule, 801D2D, and it really breaks from the old common law approach, which basically limited agent admissions to basically statements of people authorized to speak, so-called speaking agents. Instead of that, we have a very simple rule, 2 simple requirements. Number 1, at the time the statement was made, the agent or employee of the party was an agent or employee, not acting as agent employee, they just happened to have that status. So for 24 hours, 7 days a week, they have that status until they're fired, as Bob most certainly will be here soon after this incident. But the time he made the statement, he was still an employee of Freddie Cakes, so he meets the first requirement. Second requirement is a subject matter requirement. The subject matter of the statement must be something that the employee or agent would know by virtue of their job duties. Now, this is just meant to corral the scope of the exception and try to screen out what I call water cooler gossip, lunchroom chatter, by requiring that the statement be something the person would probably know by virtue of their duties. And of course, Bob meets this requirement as well. He's a truck driver, and he's talking about what he was doing while he was driving the truck. So we're pretty confident in this circumstance. It's not water cooler gossip. It's something based on personal knowledge, and that's what we're looking at. And that's all that's required. Now, it's so liberal for this simple reason. The party whose employee or agent statement is being offered is not bound to that statement in some sort of substantive agency sense. No, that's not what we're talking about here. We're simply talking about getting over a hearsay objection. That's it. The party can still dispute what the agent or employee said. They're not stuck with it, but they can't object on grounds of hearsay. That's all. It gets in, but of course it is rebuttable. Now, the other aspect here was the idea that the sign on the side of the truck couldn't be used to prove that this was a Freddie Cakes truck. And believe it or not, there have been some Georgia cases which have stumbled over this. Well, how do you know that was an AT&T truck? Well, because it had AT&T on the side? Well, yeah. What else are you supposed to do? How can you go further than that? What are you supposed to do, get the VIN number and run it backwards to see that AT&T's corporate leasing department? Come on. I mean, in our everyday affairs, things are what they appear to be most of the time. And we don't require any more exactitude than that. So the federal rule is quite simple. Inscriptions, tags, signs, etc., purporting to have been fixed in the course of business, indicating ownership, control, or origin, authenticates the item for being what it is. So yeah, sure, it could be a knockoff, but that's an issue that goes to weight and not admissibility. In a hearing on a motion for a protective order, wife offers a police report in which the officer wrote that the husband said, "I will kill her before I'll let her leave me." The officer will not testify at the hearing. Husband objects that this is double hearsay. The police report said, he said, and thus inadmissible. Number one, overruled, the report is a business record and the husband's statement is a party admission. Two, overruled, admissible under Rule 803B, matters observed pursuant to duty, and the husband's statement is a party admission. Three, sustained, what the husband said is not a matter observed by the police officer. Or four, sustained, narrative portions of a police report are inadmissible. And spread you out a little bit on that one, but number two is the correct answer. Admissible under Rule 8038B. Matters observed pursuant to duty imposed by law as to which matters there was a duty to report. Now, first of all, again, remember, those of you that hit the answer which included business records, this is a police report. It has to come in under the public record exception. Cannot get in under the business record exception. Okay, that's big. That's a big change, right? So when we have a public record, we got to go to 8038. That's where we got to be. 8038B says matters observed by a police officer. And some of you thought, well, maybe what he heard other people say wouldn't be a matter observed. But the case law is quite clear that matter observed means anything perceived. So that's anything seen, smelled, tasted, touched, and here, heard in terms of statements. So that's included. Now, we do have double hearsay here. Police report said, husband said, and when you have double hearsay like this, you're going to have to check off each and every instance of hearsay. Okay, there's no change from Georgia law in that respect. But here, under current Georgia law, Georgia considers the statements in a police report that record bystander statements as being narrative portions of the report and therefore inadmissible. Forget about all that. That narrative portions thing was something that the Supreme Court created to deal with primarily with some problems in criminal cases, and that's all gone now. So forget about narrative portions, that's meaningless. Now we have more specific guidance of 803.8B and C, as we'll see in a second. And 803.8B basically says just got to be matters observed. And the fact that it's a narrative portion doesn't make any difference. It does not disqualify it for admission. And so indeed, under the federal system, we see in civil cases and proceedings, or when offered by the criminal defendant, we see these police reports are admissible without the testimony of the police officer. As long as the statements which are recorded are independently admissible under a hearsay exception. Here, because they're admissions. Let's say you have a civil case in which a police officer goes to the scene of a fire, and one of the witnesses is all excited and says, "Oh, I saw the barn blow up with in a ball of flame." Well, that would be an excited utterance, right? That the police officer captures. So he said, the report said, the bystander said, what the report said would be admissible as a matter observed, heard by the police officer. And what the bystander said would be admissible as an excited utterance. Boom, you can get it in. Now here you got a motion for a protective order, which is still proceeding. So any restrictions or confrontation clause issues don't exist at this level. But you can see built into the rule is the confrontation law concern. Look at the excluding, however, against the accused in criminal proceedings, matters observed by police officers and other law enforcement personnel in connection with investigation. Okay, so the prosecution can use mundane matters observed by an officer, but not in connection with a specific investigation. Let me give you an example. Every DUI case, right, we try to get in a certificate of inspection of the intoxilizer. And we don't need the officer to be present in order to do that anymore under the new rules, because that would be a matter observed by the police officer in the course of mundane duties having nothing to do with any specific prosecution or investigation. I mean, when the officer, the poor trooper who's stuck with the job of going from station to station and certifying all the intoxilizers, he doesn't sit there and fill it out going, oh, I bet Sam's going to get arrested this weekend and probably blow into this intoxilizer and this will be used against him. No, he's doing a mundane record-keeping, housekeeping task. And so that is admissible under 803B, and it's non-testimonial. It's not a confrontation clause problem. If, on the other hand, the record, for example, is being done by a chemist at the drug lab and being done on a sample with the defendant's name on it, okay, then that is a matter observed pursuant to a particular specific prosecution and investigation that is testimonial, and it also is inadmissible under 803.8b. So what we're seeing here is that the public record exception and the confrontation clause work in hand in glove, as it should be. And though, again, those of you who do criminal work, whenever you make a hearsay objection to something that's testimonial, make sure you also make an independent objection on confrontation clause grounds, or you have waived it. In the same case, the police report also contains the officer's conclusion that the husband is mentally ill and the court should issue the wife a protective order. Husband objects to this portion of the report. Number one, overruled, admissible under 803.8c, factual findings of an official investigation. 2, sustained, the officer's cursory investigation does not qualify as factual findings. 3, sustained, the officer's conclusion violates the, quote, ultimate issue rule. Or 4, both 2 and 3. And gotcha. The trick question. I'll explain that in a minute. The correct answer is actually number 2. The officer's cursory investigation does not qualify as factual findings. Okay, this is a pretty broad exception. Look at this thing. We have nothing like this in Georgia right now. In civil proceedings and against the state and criminal proceedings, notice prosecution can never use 803.8c. Okay, it's completely unavailable to the prosecution. Factual findings resulting from an investigation made pursuant to authority granted by law, unless the sources of information or other circumstances indicate a lack of trustworthiness. And let me talk first about that caveat at the end. Most of the hearsay exceptions are categorical. If it falls within the rules, it's supposed to be admitted, period. Subject to a 403 analysis, but that's a long shot. There are 2 hearsay exceptions that expressly have within them giving some discretion to the judge to red light, that is, to refuse the evidence if the judge finds it's not trustworthy. Number 1, we've already talked about, the business record exception. Has an express thing, unless the circumstances, very much like this language. Here's the second one with 803.8c, factual findings. And that's in there because the drafters were aware this is pretty broad. This is new territory. Well, what kind of situations are we talking about in which you would need to use this? Well, it'd be a situation where, frankly, you don't have the author of the report. If you've got the author of the report, you don't need this exception. Okay, the report could be used as a past recollection recorded or whatnot. Okay, it's a situation where the author of the report either is no longer available or by law won't testify. Okay, so what kind of reports are we talking about under such a broad exception? Well, the case law is pretty clear. They're pretty full-scale comprehensive reports. If you look at the 11th Circuit laws, things like a CDC report on a foodborne illness outbreak, an FTC study of pricing practices in a particular industry, a EEOC report on hiring practices in a particular, you get the idea here. All right, these are agency-level, full-blown type investigations and factual findings. The courts look at several factors in deciding whether to admit. Number one, competence. The author of the report has to be somebody who is obviously and clearly competent to do this kind of factual finding. Number two, neutrality. If there's any sense in which the agency is, feathering its own nest, defending its own actions, prosecuting somebody for civil penalties or whatnot, it's off the board, can't be used. My favorite case is the one which basically says congressional fact-finding by congressional committees is presumptively admissible under this rule because it's always so partisan. No one expects those types of factual findings to be anything other than giving the answers that the particular party, minority or majority wants to have under those circumstances. Number three, it has to be pretty comprehensive. It has to kind of fit what us lawyers call due process. That all the witnesses that should have been contacted all the material facts that should be collected were collected, that different views were considered. Ideally, draft reports were released to give people a chance to comment. And we're talking about high-level stuff. And as I've been emphasizing to the judges, don't go letting in ordinary police reports, ordinary agency reports in under 8038C. Those kinds of circumstances, they're oftentimes very cursory, and they don't necessarily represent a full view of what really is going on. Now, in the area of juvenile investigation by defects and whatnot, there's one very clear distinction, and that is research and matters observed, if you talked about 8038B, by defects workers in the ordinary course of their business. Okay, I went into the home, it was filthy, there was no food in the refrigerator, et cetera, et cetera, et cetera. These are all going to be admissible under 8038B, matters observed, okay, because we don't have anything real evaluative there, all right? We don't really have anything evaluative there. When we start getting evaluative stuff, it has to qualify under 8038C for factual findings, and that's going to be kind of difficult unless it's a very, very simple observation-based opinion. Like, I found this place, to be unsuitable for small children or unsafe for small children. That kind of things will be all right. Unless DFACS is in the particular mode, they've already filed a petition, and now they're starting to basically create more of a record, which is almost an advocacy piece that they want to use at the hearing. That's different. Once they filed that petition, once they've decided to file that petition, then anything that they generate in terms of factual findings violates the neutrality requirement. Okay, so that would not be admissible. So you're looking at things which were created at a time when they had no axe to grind, they weren't pushing any particular position or advocating any particular position, they were primarily fact gathering. That kind of stuff will be admissible without the presence of the social worker. But valuative stuff, particularly valuative stuff that is put down after the decision's been made to make a petition, that stuff should not be admissible under that circumstance. Last thing you want are these sort of written closing arguments by somebody who cannot be cross-examined and questioned how they reached those conclusions. Oh, the part where I tricked you. The Federal Rule 704A technically abolishes the element issue rule. It does so only really nominally. And I'm happy to tell Georgia practitioners that you're not going to see a substantive difference. The feds still recognize the same concerns that we currently call ultimate issue rule. They just simply relabeled it. They relabeled it as, well, objection, Your Honor, this does not assist the fact finder. This does not assist the trier of fact. Why did they switch language? Well, let me go back real quickly and we'll take a little break. When they sat down to do the federal rules of evidence, They brought together a lot of lawyers, professors, and judges. And there was a hit list of certain terms that we never wanted to see anymore because they had done nothing but cause us misery. Now, Professor Thomas Green, some of you might know from the University of Georgia, was one of the first chairs of the exploratory committee in the federal. And you know what was at the top of his hit list? Res gestae. And so you'll notice, if you ever studied the federal rules of evidence, not only does res gestae never appear in the rules, it doesn't even appear in the comments. It doesn't even appear in the preliminary comments. I mean, they just simply banned it. And they also banned the term best evidence. The best evidence rule will be found nowhere in the code. Why? Because both of those things, res gestae and best evidence, were misused by various jurisdictions over the years and caused more headaches than they were worth. Well, outside of Georgia, there's a lot of states that really fumbled over ultimate issue rule, turned it into a monster, and spent a lot of judicial resources, pounding it and trying to figure out what they thought it meant and try to keep consistent about it. So that's the reason it was abolished. Now, it's never been that much of a problem in Georgia. In Georgia, the ultimate issue rule reflects two basic sub-rules, which we still have in the federal system. We just say doesn't assist the trier of fact. Number one, witnesses are not to testify in legal terms. We don't want witnesses getting up and saying, I saw this accident, and the negligence of the plaintiff or the defendant driver proximately caused the accident and the injury. No, we don't want that. That's confusing, not helpful to the fact finder, okay? So that rule is unchanged. It's just changed its name. And the second rule, of course, is we don't want witnesses invading the province of the jury or the judge, telling the judge how to decide the case. Your Honor, I'm the court-appointed advocate in this case, and I think you should do X, Y, and Z. I think this is what your protective order should look like, or I think this is how you should handle the disposition of custody. That's not helpful to the judge. Okay? What's helpful to the judge is the observations and opinions of the person with regard to the non-legal issues. Do you know this child? Do you know this arrangement? How the child relates to the parents? How the parents relate to the child? Do you know what the child's needs are? Do you know if they're getting those needs? Okay, give me all that information. And then I, the judge, will at the end of the day decide what to do about the disposition. And I will decide how to form the order. I don't need your help in doing that, even though you may be a lawyer. I don't need your help in doing that. And that's where we just have we have a sort of a line there. And what we say is, that's not helpful to me. Okay? If you just walk in and say, here, I've got a draft copy of the order, sign it, Judge. That's not helpful. The judge says, why should I sign this? Oh, you want me to give testimony? Yeah, I want facts. Okay, I want to know what you think and why you think it. And then we can talk about the order should look like. But at the end of the day, that's my job, not yours. That separation is intrinsic to the ultimate issue rule. Now we simply don't call it that anymore. We say, that's not helpful to the trier of fact if it's a lay opinion under Rule 701, if it's an expert opinion under Rule 702. Okay, and that's it. We just simply use that language. Okay, why don't we take 10 minutes, and then we'll come back and finish up with a few more slides. Okay, let's turn our attention to our next question up here. Defendant was cited for DUI. The state offers a certified copy of a report prepared by Officer Muldoon, which includes the statement, I smell alcohol on or about the defendant driver. The officer is not at trial. Defense objects on hearsay and confrontation clause grounds. Number one, sustained, the report is testimonial and is hearsay without exception. Two, sustained, although the report falls under the public record exception, it's testimonial. Three, overruled, non-testimonial and falls under the public record exception. Or four, overruled, the defense could have subpoenaed the officer if it wanted to. And some people thought it falls under the public record exception, but is testimonial. And they're wrong. The correct answer is number one. The report is testimonial and it is excluded in criminal proceedings. Okay, it's a police report with regard to a DUI case. The police officer, of course, is preparing this report in the course of a legal investigation of DUI. So it would be excluded under the public records statute. And then, of course, it's also testimonial. Remember your simple test with regard to the first gate or question you ask about, is it testimonial? Is it a statement by or to a police officer or other law enforcement agent? If the answer to that question is no, then forget about the Confrontation Clause. It's not an issue. And of course, Confrontation Clause only applies in criminal cases for prosecution evidence. Doesn't apply in civil proceedings, dealing with deprivation or dealing with a disposition. It does, of course, it does apply to delinquency proceedings because those are supposed to basically shadow criminal procedure. And so the courts consider them, since the loss of liberty is at stake, they consider them to be criminal proceedings for the purposes of the Confrontation Clause. Okay? So that's your first point. So here, you got a police report which is written in connection with an investigation. That most certainly is going to be testimonial, and it's not going to get in. So you got basically two objections here, both are valid. Hearsay and violation of the Confrontation Clause. Same case, what if Officer Muldoon does testify? Can the state get the report into evidence? Number one, no, it is still testimonial. Two, yes, it falls under the public record exception. Three, yes, if the officer cannot testify fully and accurately without the report. Yes, but only if the defense isn't paying attention. And 45% of you saw the correct issue there. 29% said it's still testimonial. If the officer testifies, Confrontation Clause problems go away. Okay, they only guarantee the right to cross-examine. Once you have the opportunity to cross-examine, then the Sixth Amendment is satisfied. Yes, the past recollection recorded rule is Federal Rule 8035. There's no real substantive difference between the old Georgia rule and the new rule on this. What we do in this circumstance, the one thing you want to avoid is this, and I remember when I first came to Georgia and I was watching trials and I would see, an expert, walk up to the witness stand with, pile of a file and sit down, put it on his lap and then just sit there and read it while he was testifying. There was no objection. I mean, what's going on? What the heck is that? And that's what this rule is all about. It's if the expert does need to refer to their notes or their file while testifying, we first lay foundation for that. So we say, Ms. Jones, can you testify fully and accurately? That's the key word. Fully and accurately, in this case, about the situation in this child's home without referring to your file. Well, no, I can't. Why not? Do you know how big my caseload is? Do you know how many cases I have open? And I don't want to confuse or get confused and confuse something in this case with another case. I want to testify fully and accurately. Okay? Now, this file that you have in your lap, who made the notations in there? Well, I did. You make those notations at a time when your memory was fresh? Yes, I did. Okay. They're showing that the record was made when the memory of the witness was fresh, or that they adopted it as true when their memory was fresh, satisfies the foundational requirements for the past recollection recorded. Now, what can the witness then do? The witness can then read freely from the file as they answer questions. You could publish. You could put up in PowerPoint. You could do anything with that file in the courtroom. But if it's a jury case, it doesn't go back with the jury over a continuing witness objection. Okay. In a divorce case, wife's witness testifies that as he and husband's neighbor drove by the no-tell motel, the neighbor pointed at a man and woman walking into a room and said, "Why, that's Al and his secretary." Assume the husband's name is Al. Defense objects that this is hearsay. Overruled, res gestae. 2, overruled, exception for present sense impressions. 3, sustained, no foundation that the neighbor spoke from personal knowledge. Or 4, sustained, what happens at no-tell stays at no-tell. we start getting a drop-off in responses about this part of the program. As some people say, I'm tired of being humiliated. Hang in there, keep guessing. And 62% of you got that right, exception for present sense impressions. Okay, the res gestae rule is dead, gone. Well, in 30 days, 31 days. Will no longer be cursed with the res gestae rule. And that's a good thing, because that is a crazy, unpredictable, and very vague rule. I first moved to Georgia 29 years ago. Dean Johnson, former dean of Emory Law School and our first dean at Georgia State, he called me and he said, you're going to be teaching evidence. I want you to go down to the courthouse and start seeing how we do it in Georgia. We do it a little different here. I had practiced law in Seattle, where we had already passed the federal rules in 1976. So I was very familiar with the federal rules of evidence. And I'd never heard the term res gestae in my life. And I go down to the Fulton County Courthouse. I'm watching a criminal trial. And about 5 minutes into the trial, the prosecution's putting on some obvious hearsay, and the defense jumps up, objection, hearsay. And prosecutor goes, res gestae. Judge goes, overrule. Oh, what the hell is that? What just happened? And then a few minutes later, it happened again. Objection, hearsay, res gestae. Judge goes, overrule. I go, man, you really do things different here in Georgia. What is this? Now, I grew up an altar boy. I was an altar boy when I was young. I knew it meant things done, but that didn't help. Objection, hearsay, things done, overrule. Yeah, it wasn't the Latin. It wasn't the Latin. It just didn't make any sense to me. So I went and asked my mentor when I first moved to Georgia, was John Marshall, who was the leading trial attorney with Paul Goldstein and the maven of Georgia evidence law for many years. And I went and I asked John, I said, John, you got to help me out here. What is this res gestae rule? And John, in his famous baritone voice, says to me, oh, Paul, it's very simple. The judge likes you, it gets in. The judge doesn't like you, it doesn't get in. Oh, things are different in Georgia. And I despaired of that, and then watched as I wrote my books and compiled these obviously absurd cases, in which one case would say that a statement 15 minutes after the event was not in the res gestae, it was too late, and then another statement said 20 minutes was okay. And it's a little hard to square those. And I'd ask judges, what do you do with those cases? And they said, well, you know, a little round thing down by your feet, that's where I throw those cases. That's where I file those, because they're not giving me any guidance whatsoever. Okay, so I just kind of, in fact, there was a famous Supreme Court case in which Justice Weltner, after a few paragraphs of saying what an absurd doctrine res gestae was, declared the holding of the court was, trial courts will not be overturned on a res gestae ruling unless it's the clearest abuse of discretion. And there's been only basically one case that's fit that category since that opinion. And that was a case in which a written statement was admitted under the res gestae rule. Think about that. Okay, the idea of res gestae is supposed to be a spontaneous statement. So obviously the declarant was spontaneously, as if moved by the Spirit of the Lord, was writing out this statement. And even the Court of Appeals said, now we're going too far. Now we're going just too far. So we got rid of res gestae. I think Virginia is the only state left that still has the doctrine. What did we replace it with? Well, over the course of the 300 and some odd years of res gestae, there were some lines of cases which made some sense. So the drafters of the federal rules basically picked up res gestae's greatest hits. And those are 803.1, 2, and 3. And they work pretty well. In doing research for my books, looking at the 35 years plus that these rules have been in the federal courts, there's not a whole lot of tripping over these rules. They're pretty straightforward, and what I like about that as a litigator is it gives me predictability. Okay, I mean, I was always obsessive compulsive as a trial lawyer. I wanted to know exactly what I was going to be able to get in and exactly what I could keep out. And that was very important to my evaluation of the case, whether I suggested my client settle or not, or take a plea. Those things were vital to me. And that's what 803.1, 2, and 3 is going to give you. It's going to give you a much higher level of predictability, of certainty, as to what you can get in and what you can't. And here's the first of the three, 803.1, present sense impression. Now, this is a statement describing or explaining an event or condition while the declarant is perceiving it, or immediately thereafter. And I want to emphasize immediately thereafter, the federal cases are well aware of what happened with res gestae. And so they're quite insistent that the statement be made at the time the event is being perceived or as soon as it takes to get out of the mouth of the person who's perceiving it. That's what immediately thereafter means. Recognizing we're not all Al Michaels, and we can basically do play-by-play right over as it's going on. That our brains are maybe, particularly those of us in our 60s like me, where we're a little slower. And so it takes us a little time to articulate what we're perceiving. 8031 is basically outward looking. It is statements about what's going on in the external world. What I'm seeing, hearing, tasting, feeling. So it has to be descriptive statements we're looking at. And of course, they have to be basically present tense statements. Backward-looking statements don't qualify. You know, I saw the moon rise last night. No, that's a backward-looking statement, narrative, something in the past, doesn't qualify. But to be standing next to somebody and saying, this is a beautiful moonrise, okay, that's good. That is a present tense statement and qualifies under the rule. Number 18, a witness testifies on direct that right after she saw the defendant's car hit the telephone pole, she told her companion, well, that moron, he was talking on his cell phone. Defense objects that this is hearsay. Number 1, sustained. The out-of-court statements of a testifying witness are hearsay. 2, sustained. This is improper bolstering of the witness's credibility. 3, overruled. The statement is not offered to prove that the defendant is, in fact, a moron. Or 4, overruled. The out-of-court statement is admissible as an excited utterance. And 78% of you nailed that one. Very good. Okay. All of you are aware that under current Georgia law in a definition of hearsay does not consider the out-of-court statements of a testifying witness to be hearsay. Federal rules do, which is really confusing. I might spend a lot of time in teaching my evidence students about hearsay, that hearsay is all about problem of credibility. How do you evaluate a source of information when that information is not at trial? The jury never gets to view their demeanor. They're not under oath, and most importantly, they're not cross-examined. That's the problem with hearsay. And there's always some, student in the front row who raises their hand and says, Professor, if that's the problem with hearsay, then why do the rules say that the out-of-court statements of a testifying witness are hearsay? And he's in court, he's under oath, he's subject to cross-examination. The answer is very academic, and I don't bore even my own students with it. And I'm not going to bore you with it either, okay? But suffice it to say, it is simply, to me, incoherent. So when we worked at the State Bar on the new evidence code, we said, do we really need to buy into confusion? And I came in with some cases which demonstrated that it had caused some confusion in some cases. The Court of Appeals would have to work out and remand. And so we said, heck with that. We're going to keep Georgia's more coherent position. And that's what we did. Georgia basically says this: the prior out-of-court statements of a testifying witness are not hearsay, but that doesn't mean they're all admissible. The prior out-of-court statements have to be doing some work, okay? And there are 3 ways in which such statements do work. 1, they might be a prior inconsistent statement, which obviously is doing the work of impeaching the credibility of the witness. Or they can be a prior consistent statement that rebuts an attack on the witness's credibility. Okay, the witness takes a stand and he says, I saw the PT Cruiser, it ran a red light. Well, Mr. Witness, did you tell anyone else that? Oh, yes. Oh, yes, I went home and I told my wife the PT Cruiser ran a red light. Anyone else? You're the mailman. I told the mailman, PT Cruiser ran a red light. And anyone else? Oh, yes, told my dog Fluffy. Hey, Fluffy, PT Cruiser ran the red light. What are we getting with this? We're getting a reiteration of the same thing over and over again. Does that add to its persuasiveness? Logically, it doesn't. Logically, it makes no sense, right? If you're walking down the street and you see a newspaper, and a newspaper says, Georgia Tech wins 3 in a row, and you say, that can't be right. So you buy another copy of the same newspaper, and you go, oh, I guess it is. Doesn't make any sense. If it's wrong in one iteration, it's wrong in every iteration. But we know psychologically that it can be persuasive for illogical reasons. It's like the big lie technique, right? They keep hearing it over and over again, and they build more confidence in it. So the law has always refused to admit a prior consistent statement when the only work it's doing is repeating the direct testimony. When the only thing it's doing is, and here's the proper objection in Georgia, past and future, improper bolstering of the witness's testimony. Improper bolstering. All you're doing is giving us multiple cumulative iterations of the very same thing you just said on the witness stand under oath. That doesn't make it more likely to be true at all. Well, when does a prior consistent statement work? When it rebuts an attack on credibility. Mr. Witness, did you see what happened? Yes, the PT Cruiser ran the red light. No more questions, you're witness. Cross-examination. Well, Mr. Witness, isn't it true you're romantically involved with the plaintiff? Yes, that's true. No more questions. Okay, the witness has been attacked on the basis of bias. Redirect, and this is where proper prior consistent statements normally come. Redirect. Mr. Witness, when did you become romantically involved with the plaintiff? Well, actually, it was at the accident itself. Yes, I slipped my phone number into her gurney as they were taking her away to the hospital. Well, were you romantically involved with her at the time you made a statement to Officer Jones right after the accident? No, I wasn't. And what statement did you make to Officer Jones minutes after the accident? I said to him, the PT Cruiser ran the red light. You see how it works? Okay, there, the prior consistent statement is doing some work. It is basically untarnishing the direct testimony which was attacked on cross-examination. It is basically refuting it, rebutting it. And so that is admissible. The third type of prior out-of-court statement of a testifying witness that is admissible is one which is admissible under 803 hearsay exceptions, okay? Because they're always admissible. Whether the witness testifies or not, we're always going to admit a statement like this in excited utterance by the witness. And excited utterance is number 2 of our 3 res gestae-based exceptions, a statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by that event or condition. There's 2 major limitations on this. Now, of course, this is the one that looks most like res gestae. There are 2 limitations on this. Both of them would be familiar to anyone that practice using res gestae because they're also existent under current law. Number 1, when we talk about how long a person is under the stress or excitement of an event, we have to take into account the obvious, which is how stressful or exciting was that event? Okay, everyone knows that part. That's the easy part. The other part is what motive did the person have to recover from the excitement and start to deliberate? In other words, did the speaker have a motive to get a hold of himself, as we say? Don't we say that? Get a hold of yourself. The idea of an excited utterance is it's spontaneous. It's a response to an exciting event. But when the person who is speaking is a person who has a motivation to spin a story, to fabricate, to shift blame, that person's very quickly going to get over the excitement of the event. They're going to get a hold of themselves and start deliberating. 4-year-old child knocks over mom's favorite vase. How long does it take a 4-year-old to start concocting that story? I mean, the glass is barely shattered when the child, basically after shaking their hands like little kids do when they break something, goes, my sister did it. Yeah, my dog Fluffy did it. Of course, and that's the break. That's no longer reliable because it's based on deliberation, because they're trying to spin a story, because they got a motive to fabricate. They're no longer under the stress of the event. They're under the stress of trying to figure out a story they can sell, and that does not qualify under the rule. The second constraint we want to look for here is the personal knowledge requirement. Well, make sure we stick with that. The Cartwright case in Georgia has already recognized this under res gestae. You have a shooting. The police arrive at the scene. 20 minutes after the shooting, they see 3 eyewitnesses standing over in the corner talking to each other. Gee, I wonder what they're talking about. The Falcons game last night? No, they're talking about a shooting that they just saw. And what they're trying to do, of course, is gap fill, share stories, commingle their stories. And what we're getting is double, triple hearsay. We're no longer getting that pure, spontaneous statement of personal knowledge from the declarant. it no longer qualifies under the rule. So you want to look and keep in mind those two major constraints on the excited utterance exception. In a personal injury case, Bill, plaintiff's husband, testifies that a week after the accident, his wife told him, "My neck is really sore." The defense objects this is hearsay. Sustained, a week after the accident is too long to qualify as part of the res gestae. 2, sustained, the statement is self-serving and inadmissible on that basis. 3, overruled under the exception for then existing physical conditions. Or 4, overruled if offered to prove that her husband was, in fact, a pain in her neck. And number 3 is correct. I think about 4 of you said number 1. No, res gestae will be gone. About 5 of you picked number 2. The statement is self-serving and inadmissible on that basis. Yeah, there is an old Georgia rule which excludes so-called self-serving statements. Even our own appellate courts, though, in more recent decisions, have acknowledged that that really isn't a separate basis for excluding evidence. It's just simply one way of describing the problem with certain kinds of hearsay. Well, under the new rules, forget about self-serving altogether. You can't use it as any kind of independent objection. The fact that a statement which is otherwise admissible under the rules of evidence is self-serving goes to weight and not admissibility. There are few things easier for a jury to recognize than when something is self-serving. They don't have a problem with that. And they know how to give it, to look at it in the way that they're supposed to look at it. So we never exclude under the new rules something because we think it's self-serving. Now the biggie here is 8033. This is a huge exception, and you're going to find it very powerful, but like a very powerful horse, you're going to have to keep it on the rein, like a thoroughbred. This is very powerful, but it also has the capacity to get way out of line if you don't know how to control it. So let's take a few minutes to look at this. Now, remember 8031 was statements about what's going on in the external world? This one is about things going on inside you. What I'm feeling. I am hungry. My neck hurts. What I'm thinking. I intend to go to Savannah tomorrow. My emotional state. I'm sad. Okay, all of these are then existing statements of then existing mental, emotional, physical conditions. Okay, think about how big that is. Then existing mental, emotional, physical conditions. Now, they can't be backward looking. That excludes them. The simplest ones, of course, are statements of then existing physical condition. My neck hurts. My neck hurt last Tuesday. No, that doesn't qualify. That's backward looking. Okay, so basically we're looking again, present tense type statements. Okay, let's delve into 8033 a little deeper. On the issue of whether wife gave husband a Rolex watch, which he denies, Pat testifies that wife said, "I plan to give my husband a $50,000 Rolex for his birthday." Husband objects, hearsay. Number 1, not hearsay, but original evidence. 2, overruled under the exception for statements of then existing intent. 3, sustained, her intent is not an issue. 4, sustained, hearsay without exception. And the correct answer is number 2. Half of you got that right. And the fact that 40% of you took number 3 underscores exactly why I include this slide. We're used to the idea that when intent is an issue, then a statement of a person's then existing intent would be relevant and admissible. But notice how 8033 allows a different kind of use of intent. Use of a statement of intent to prove the person probably carried out what they said they were going to do. So, in a criminal case, I have an alibi defense. I say I was in Savannah on the day of the robbery and not Atlanta. I have a witness who testifies, yeah, I talked to Paul the day before the robbery, and he told me I plan to go to Savannah tomorrow. Well, that's admissible that I did go to Savannah the next day. Okay, so you notice a statement of intent is not admissible just to prove the person's intent, but to prove as circumstantial evidence that the person probably went ahead with that intent. Notice the rule includes such as intent, plan, motive, design. In other words, looking at what I'm thinking of doing right now as circumstantial evidence that I probably went through with it. That's a huge expansion of the rule. That's a huge expansion of the rule. Wife's sister testifies that wife said, I believe Fred, husband, is molesting the kids. Husband objects that this is hearsay. Number one, overruled exception for statement of her then existing mental condition. Here, the wife's belief. Two, overruled if offered only to prove why wife took the kids and left the house. Three, sustained if only offered to prove the truth of the matter is believed, that husband molested the kids. Or four, both 2 and 3. And we'll really spread you out on that one. The correct answer is 4. Okay, those of you that said both of those were correct. Let's go back and look at those a second. Number 2 would be non-hearsay, wouldn't it? If it's only offered to prove why she took the kids and left the house, then her belief doesn't have to be true. She just has to have that belief, and therefore it wouldn't be hearsay. If, on the other hand, it is offered to prove that, in fact, the husband was molesting the kids, then it falls under this qualifying caveat in 8033, which is so important. Not including a statement of memory or belief to prove the fact remembered or believed. If that caveat weren't in the rule, 8033 would just eat up the hearsay rule. It would just devour it. Because all hearsay could be stated in terms of a statement of belief or memory offered to prove the truth of that belief or that memory. So this caveat is absolutely essential. And it is the trick to understanding how to parse 8033 statements. And that's what you're going to have to learn to do. Because a lot of times you're going to get statements in which part of it's admissible under 8033 and part of it is not. Let me give you a simple example. A witness testifies that the victim wife said, I'm afraid of my husband. I'm afraid he's going to kill me. Think about that. The first part of that statement, I'm afraid of my husband, that's admissible under 8033. She's simply talking only about her own feelings at that time. I'm afraid of my husband. Second part of the statement, I'm afraid he's going to kill me, is offered to prove a belief on her part as to what her husband intends to do, to prove that he probably intended to do it. And that is inadmissible under 8033. So we're always going to be parsing these statements to collect what we can, statement of the person's own then existing feelings, but excluding statements of belief or memory about what other people think, what other people intend, what other people are doing or not doing. The other example in this area is with that statement of intent. Remember the witness who said, Paul said, I plan to go to Savannah tomorrow. We said that's admissible. Admissible under 8033 to prove that I probably went to Savannah tomorrow. But suppose that the statement was, Paul said, I plan to go to Savannah tomorrow with Karen. Whoops. That latter part is a statement of my belief that Karen intends to go to Savannah with me. Some of you evidence scholars would recognize that as the old Hillman problem from the Hillman case. We won't go into that. Suffice it to say that that issue split the federal courts, and we wrote directly into 8033 that not including the statement of belief is to the intent of another person. Okay? So if the statement is offered, he said, I intend to go to Savannah tomorrow with Karen, only the first part of that statement, that I intended to go to Savannah tomorrow, would be admissible, not the part in which I incorporate my belief as to what Karen intends to do. So what you're going to find is the same thing that people that practice a lot in federal court find. And that is you're going to be spending a lot of time playing with this 8033 and parsing these types of statements. And the key to it is that underscored part, not including a statement of memory or belief to prove the fact remembered or believed. Those are the reins on this horse, this powerful horse. If you keep that in mind make sure that you parse out statements that run afoul of that exclusion, then you'll control it really rather well. Here's the one we'd already talked about. I want to get to the two final slides before we finish for the day. And again, I'll get all of these slides to Melissa so you all have a chance to see them. Here we go. Domestic violence case. Defendant's wife reported to the police that her husband beat her up the previous day. Wife now asserts a marital privilege and refuses to testify at trial. The prosecution asked the court to compel her to testify. Number one, the wife may assert the privilege unless children were present during the violence. 2, the wife may assert the privilege, but her statement to the police is admissible. 3, the wife may assert the privilege and her statement to the police is inadmissible. Or 4, if the trial takes place after January 1, 2013, she may not assert the privilege. Wow, I would have thought this group would have gotten this better. This is number 4 is the right answer. Okay, the exception has been expanded. Okay, her statement to the police, by the way, would not be admissible. That would be a classic testimonial statement. She made to the police day after the incident. Okay, the emergency's over, etc. So that would be a classical testimonial statement. So the problem here is if she asserts the privilege and we can't get her statement in, we got nothing. Okay. When we did the review of the evidence code, the issue came up. We have an exception for the marital privileges for crimes against the child. You're all familiar with that. And the question came up, should we expand, like many states have done, expand that exception to interspousal crime? At that time, the victims' rights groups were undecided, and we're still discussing it. So the legislature basically said, we won't do anything this time, but come back next session, and they did. A bunch of groups got together, they decided, yes, we want this exception. And so the legislature passed it last year, and it basically said the effective date should be the same as the new code. So as of January 1st, 2013, the marital privileges, both of them, witness immunity privilege and the confidence privilege, are unavailable in cases of interspousal violence. And we join a majority of states to take that position. And connected with that, there's our last slide. In the same case, wife still refuses to testify despite a court order to do so. Prior to trial, the wife's sister tells the court that the wife told her the defendant threatened to kill her dog Fluffy if the wife testified against him. Does this make the wife's statement to the police admissible? Now, we've already talked about how that statement to the police the day after the incident reporting the crime is clearly testimonial, clearly barred by the confrontation clause if the wife doesn't testify and subject herself to cross-examination. The question here is, do these facts change that outcome? Number 1, no, the wife is not unavailable as required by the forfeiture exception. 2, no, what the sister said is double hearsay. Wife said, defendant said. 3, yes, if the court finds it more likely than not the sister is telling the truth. Or 4, yes, the wife's statement to the police is an excited utterance. And majority of you, 46%, got that one right. It is number 3. This is the forfeiture exception to hearsay. It requires that the declarant be unavailable as a witness, but unavailability doesn't mean the person is asserting a valid privilege. I mean, that would include that. But even if the witness is not asserting a valid privilege, if they refuse to testify after a court order to do so, they're unavailable for the purposes of the 804B exceptions. And this, of course, is an 804B exception. This would be a statement offered against the party, that'd be the husband in this case, who has engaged or acquiesced in wrongdoing that was intended to and did procure the unavailability of the declarant as a witness. See, the husband can't complain, oh, well, I don't get to cross-examine her. Well, you threatened her dog Fluffy to keep her off the stand. And that's improper, of course, and it forfeits his right to cross-examination, not only as a hearsay rule, but also under the Confrontation Clause. Crawford itself introduced the forfeiture exception, and it was reiterated in Davis after that fact. So this would be a twofer in this circumstance. So again, we're back to 104A, aren't we, where we started. The judge has to decide whether the forfeiture exception's met here. He can consider any evidence that's not privileged, including hearsay. So he basically says to defense counsel and the prosecutor, come on in the chambers. The sister wants to talk. She comes in. She doesn't even have to be sworn. She just basically says, this is what she told me. She told me, he said, I'm going to kill that dog Fluffy if you testify. She says, well, you know, Fluffy's the only thing I love in this world, so I'm not going to do it. And that's why she's not testifying. If the judge finds by preponderance of the evidence that that story is straight, then the judge will then invoke the forfeiture exception and admit it over a Confrontation Clause objection as well as a hearsay objection. Now, I've already taken you over 4 minutes, but I want to thank you all for paying attention today. Just leave your clickers where they are, and good luck with these new rules. I'm leaving town, personally.